All right, good afternoon. Welcome, everyone. My name is Leo Lane. I'm a lawyer here in Whitehorse, and I sit as a member of the Law Society's Continuing Professional Development Committee. For our final CPD session of 2021, I'm pleased to welcome back two presenters from the Yukon Human Rights Commission, who are going to help guide us through a pressing and at times divisive issue, government and private sector vaccine mandates in the Yukon. Our speakers will be discussing how the Yukon Human Rights Act might apply where employers, landlords, or service providers treat people differently depending on their vaccination status. We have Burju Ditani, the Director of Human Rights for the Yukon Territory. He's originally from Calgary, obtained an LLB from the University of Wales, and LLM in Public International Law at the London School of Economics, and studied also at Cambridge University. Before coming to Yukon in the fall of 2020, Burju was Assistant Regional Director with the Alberta Human Rights Commission and a teaching fellow in the Faculty of Law at the School of Oriental and African Studies in London. Joining Burju is Amna Bhatti, Human Rights Officer at the Yukon Human Rights Commission. Amna received her BA and LLB from Lahore University of Management Sciences and completed an LLM at Osgoode while interning with the Ontario Ministry of Attorney General. She was called to the bar in Ontario and then joined Lawyers for Human Rights in South Africa, working on projects in their gender equality program. Amna and Burju will be presenting together momentarily. They have a PowerPoint slide deck that we can send to members upon request. Please email Lynn Pigage if you would like to receive a copy of the presentation after we're finished. And the entire session today should take about 90 minutes. It will count as an hour and a half towards your mandatory 12 hours of annual continuing professional development. And we've set aside roughly 45 minutes for the presentation, with the remaining time devoted to question and answer session. Now, because of the number of participants registered, we ask that you use the Q&A feature in Zoom to type in your questions. And if your Zoom username doesn't show up on the screen, or sorry, if your Zoom username is not the same as your real life name, if you would just please identify yourself in your question when you type it. This will help the presenters in case they want to talk to you directly for clarification, or if there's any follow-up discussion. You can submit your questions at any time during the presentation, but I won't be reading them for our presenters until we get to the end. So now I'm going to turn things over to our speakers, and I will rejoin you for the Q&A afterwards. Welcome, Amna and Burju.
Perfect. So I'll flip it over.
Yeah, just click the screen share.
Sure. So thank you everyone for joining us this afternoon. And in particular, thank you to the Law Society for, it was upon our request that the CPD session was set up, and they dealt with the request with speed and nimbleness. So I'd like to thank the Law Society for doing so quickly and so readily. And that being said, I'm momentarily going to turn things over to Amna as just after a few clicks of the mouse.
I'm just trying to move that out of the way. Good afternoon, everyone. Thank you to the Law Society again for having us, and for Leo for moderating this. I have to.
Oh, just
I think I'll move it as we speak.
Sure.
Okay, just so I can operate it.
It's like warming up a car. It takes a few minutes to find a rhythm and get going. So
I can't see the. Okay, I guess.
So we are honored to live, work, and travel within the traditional territories of all 14 Yukon First Nations. We respectfully acknowledge that Whitehorse is in the traditional territories of Kwanlundun First Nation and Tan-Quechan Council. Je reconnais respectueusement que je vis et travaille au sein de territoires traditionnels de la Première Nation Kwanlundun et du Conseil Tan-Quechan.
And just before we begin the presentation, I just want to note that this presentation is for general informational purposes only. And this is legal information and not legal advice. And if you have any specific questions, please contact the Yukon Human Rights Commission.
So the Yukon Human Rights Commission is a statutory agency that promotes equality and diversity through research, education, and enforcement of the Yukon Human Rights Act. So we have an infographic on the left there, which are the 5 parts of our mandate. Most of those are self-explanatory, so I won't get into these in any detail at all. And again, this event takes at least 3 of these 5, but that's basically the commission and a little bit about our mandate and what we do.
Right.
Yeah, there you go.
Okay. So before we begin, the agenda for today's presentation is, we'll first start off by going over some basics of, some terminology and important things we need to know about the presentation. Then we'll go over the vaccine mandate under the Yukon Human Rights Act. We'll discuss the duty to accommodate and arrive at some common scenarios. We will bring up the scenarios in the beginning just so everyone has a chance to look at them and sort of, get their gears going. And then once we present, you'll have a better idea of what the answers to those questions might be. And at the end, we'll go over the complaints process at the commission. So I'll just let everyone go ahead and take some time to go over these for a little bit.
So a few scenarios for you to absorb and consider. 3 fairly common scenarios that form the basis of a lot of the inquiries that we receive. So the first is, I am a landlord. Can I post an ad for subletting my apartment specifying that only vaccinated persons should apply? The second is, I have an undiagnosed condition that precludes me from getting vaccinated. I rely on herbal treatments to deal with my medical issues. What do I need to provide to a restaurant? And the third is, I don't need to be vaccinated because I believe that God will protect me. My employer is mandating vaccination. What are my rights? And so we're going to return to these towards the end of the presentation after we've provided some substantive information about how human rights law operates in the space. But undoubtedly, some of you will have thoughts on all 3 of these scenarios, and it will be interesting to see the extent to which the needle is moved with respect to your thinking on these 3 rather common scenarios. So just consider that as we move through the presentation this afternoon.
So we'll begin by describing discrimination, and we call it prima facie discrimination when we're conducting this analysis under the Act. We get the test from, it's a 3-part test that we get from Moore. The first part is, is the complainant a member of a group protected under a prohibited ground? And we will go over grounds and areas under the Act in a little bit. The second component of the test is, has the complainant experienced unfavorable treatment? And the third component is establishing the nexus between the prohibited ground and the unfavorable treatment. And so a few things to remember is that intention is irrelevant when we're determining whether or not there's been discrimination, and it is the effect that matters. And the second point is that discrimination can be established on the basis of circumstantial evidence, and as you may be aware, it's usually rather difficult to prove human rights issues and discrimination, so circumstantial evidence is valid. Okay, so just a few other things to consider are the fact that employers, landlords, and service providers, duty bearers, have an obligation to protect their employees, tenants, and customers. And so if duty bearers are implementing safety measures to, let's say, reduce the spread of COVID-19 through mandatory vaccination policies, and if they are, implemented in good faith and in accordance with directives from the Chief Medical Officer of Health, then they are most likely not violating the Yukon Human Rights Act. I'll let you do this. Okay, sorry.
Yes.
And so the second thing is that, however, if a person is facing discrimination on the basis of a protected ground within a protected area under the Act, then they may have a valid human rights complaint. And we will, of course, go into more detail on what protected grounds and protected areas are and what would be a valid complaint under the Act. And the third point is that if a duty bearer fails to accommodate a person's particular needs or request for accommodation to a point of undue hardship, then they may have a valid human rights complaint under the Act.
Last point to note here is that the Commission will not accept complaints regarding opposition to vaccination based on personal preference or personal belief, or any other reason that is not related to a ground protected under the Act. And so we've appended just at the bottom of that bullet point a fairly recent decision of the Alberta Human Rights Tribunal, Pelletier and Community Natural Health Foods at paragraph 32, where they discuss personal preference and personal belief as distinct to protected characteristics. So again, not a lot of case law on vaccines yet. There have been some decisions on mask mandates, which are going to be helpful going forward. And they are, of course, analogous to what we can expect relative to vaccine mandates. And just to go over some of the protected areas under the Yukon Human Rights Act. And so again, these are pretty self-explanatory. So we have services, goods, or facilities provided to the public, any aspect of employment, housing, including occupancy, possession, lease, or sale. We have membership in or representation by a trade union or association, occupational or professional association. And lastly, we have public contracts. With respect to vaccine mandates, the ones that are going to be the most impacted are those first three, or the most prominent infographics that you see there. So goods and services, employment, and housing are what will typically engage the Human Rights Act relative to vaccine mandates. A couple of things to note, just in terms of exceptions. In terms of employment, the Act doesn't apply to the employment of a person to provide services in a private home or in any exclusively religious, charitable, educational, social, cultural, or athletic organization. So you find that at section 11, subsection 3A of the Act. Section 35, employers are responsible for the discriminatory conduct of their employees unless it is established that the employer did not consent to the conduct and took care to prevent the conduct, or after learning of the conduct, tried to rectify the situation. That's section 35. So that just codifies the idea of vicarious corporate responsibility. And in terms of tenancy, the Act doesn't apply to the choice by an occupant of a private home of a boarder or tenant to occupy part of the home. So that's section 11.3b, and that deals with the very common occurrence of if you own your own home and you want a roommate, the Act isn't going to apply to you there for a lot of obvious reasons.
So this slide is on grounds, which are basically personal characteristics that a person may have on the basis of which they may be discriminated. Our video is sort of...
No, it doesn't.
It's not going to? Okay. So there are 14 of them under the Yukon Human Rights Act, and I'll let everyone take a moment to go through them. For obvious reasons, for vaccine mandate related issues, some of them come up more often than the others, or are more relevant, like religion and physical and mental disability. but yeah, and so there's also like age and family status that may come up, or political beliefs and creed. We will go over them in more detail. But yeah, I think that's it for this. So the first protected ground that we are going to discuss in a little bit more detail is disability. And of course, it comes up a lot in terms of the mandatory vaccine policies. So Section 37 of the Act defines physical disability as any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness. However, case law has established that disability is a lot broader for the purposes of discrimination. And so the definition of disability can be interpreted to extend to actual or perceived possibility that an individual has or may develop a disability. And another thing is that a person seeking an accommodation on the ground of disability may need to provide medical information that indicates restrictions. And so the question that often arises is, how much information do you need to provide to a duty bearer to seek accommodation? And so case law, like Pelletier that Bridget just mentioned, which is quite recent, and then there's a bunch of other case law as well, basically tells us that you need to give enough information in the form of a doctor's note, mostly, that explains what disability you have, what may be the restrictions falling from that disability that would not let you get a vaccine, and what accommodations you may require for not being able to get the vaccine and for accommodation. However, you don't have to provide a diagnosis for the disability for it to be enough to seek accommodation.
So we move on to, I think, the protected ground that, especially according to media reports, and it also happens to be true, has caused probably the greatest degree of difficulty for people to navigate. Employers, lawyers, to a certain extent, complainants, everyone struggles with this, which is religious belief and or creed. There are many interesting philosophical rabbit holes, which I'm going to try and avoid this afternoon when discussing religious belief. But we'll set out the legal framework in terms of how this is dealt with. And so the first thing to be said is that a claimant must demonstrate that they sincerely believe in a practice or belief that has a nexus with religion, irrespective of whether a particular practice or belief is required by official religious dogma or is in conformity with the position of religious officials. And that's a quote from the leading case on this from the Supreme Court of Canada, which is Syndicat No Clest and Amselem, decided back in 2004, cited hundreds and hundreds of times in later jurisprudence. So Amselem remains the leading case for this, and Amselem stands for the proposition that for the protection to be triggered, a claimant must demonstrate, firstly, that they hold a sincere belief. So the belief must be sincere as opposed to correct. And secondly, that it has a nexus with religion. Second, the second bullet point states that the state should not be the arbiter of the correctness of a person's religious belief. So in a sense, this is an editorialization and commentary on what Amselem is saying. So the reason we're looking for the sincerity of the belief rather than the correctness is you can imagine a nightmare scenario where the court is telling you what a good Catholic or a good Muslim is by saying, no, you actually believe the following. And again, one of the philosophical rabbit holes I'm going to try and avoid is naturally religions have schisms and sects in them that tend to believe different things. So understanding what is correct is immensely difficult. And I'm sure that many of the people that minored in religious studies that are attending this could attest to that. Third bullet point says here that competing rights claims should be reconciled through accommodation if possible. So there should be an avoidance of blanket rules without any consideration for individual circumstances. Naturally, there's going to be competing rights. The first attempt should be to try and resolve those competing rights, those conflicts, through accommodation where possible. So there is no space where that does not happen. And so the leading case there, RNNS, was dealing with precisely this. The idea of a blanket ban on religious, in this case, a face veil, Muslim woman or woman who identified as Muslim attempting to give evidence in a court. The court's assertion that the court did not have to consider accommodation was rejected by the Supreme Court of Canada. Fourth bullet point states that the complainant must prove objectively that the practice or belief in question has actually been infringed. And that comes from SNL and Commission Scolaire des Chaînes, another Supreme Court decision. We have the citation there for you. I find it most helpful to think of this the way that the Ontario Superior Courts did in a decision called Bars and Children's Aid Society of Hamilton. And so at paragraph 59 and 60, the court said that there's really two things you're looking for when dealing with religious belief as a protected characteristic. At the first stage, a claimant must show only that his or her religious belief is sincere. As a religious belief is claimed in good faith and that is not fictitious or arbitrary, inquiries into a complainant's sincerity must be as limited as possible. So the first thing you're looking for is the sincerity of that religious belief. And that's qualified by the courts as saying that basically, if the religious belief is claimed in good faith and it's not fictitious or arbitrary, that will be enough to satisfy that first requirement. And inquiries into a claimant's sincerity should be as limited as possible. It's the first point. At the second stage, a claimant must put forward objective proof of an interference with the religious practice. It is not enough for a person to say that his or her religious beliefs have been infringed. The person must prove the infringement on a balance of probabilities. Proving the infringement requires an objective analysis of the rules, events, or acts that interfere with the exercise of the freedom. So in other words, it wouldn't be sufficient for a person to say, I sincerely believe that vaccine mandates will violate my religious belief or my religious practice. The burden of proof is on the complainant to demonstrate that the measure in question adopted by a duty bearer, so let's say an employer, actually and objectively infringes on the religious belief. Not that it might infringe on it, and not that the person claiming the right believes that it will. So to the extent that there's a subjective test to it, which is the sincerity of the religious belief, that's the only place where there's a subjective test. The rest of this is objective. I'm sure that there might be questions on this, but that's basically the protected characteristic of religion and the framework in terms of how that protection operates under human rights law. And you'll notice too that a lot of these cases are charter jurisprudence, but they've been applied copiously in human rights cases as well. So it's fair to assume that for the most part, and with very few exceptions, that charter jurisprudence is going to be mirrored in human rights processes and proceedings.
And now we move on to the protected ground of creed. So creed is often conflated with a person's personal opinion or personal belief, but there's actually a rather straightforward test that was applied in Vezina by the Ontario Tribunal, and it was later also adopted in Sharma in a more recent case. Just gonna. And so it's a 5-part test, which basically it wasn't a part of the law itself, but it was a part of a policy on preventing discrimination based on creed that was adopted by the Ontario Human Rights Commission. And so the first part is the creed is defined as a belief system that may have the following characteristics. And the first is it is sincerely, freely, and deeply held. It is integrally linked to a person's self-definition and spiritual fulfillment. It is a particular, comprehensive, and overarching system of belief that governs one's conduct and practices. it addresses ultimate questions of human existence, including ideas about life, purpose, death, and the existence or non-existence of a creator and or a higher or different order of existence. And it has some nexus or connection to an organization or community that professes a shared system of belief. And so based on that definition, it kind of this is how it becomes sort of easier to separate a person's personal opinion or belief, let's say for not getting a vaccine, from an actual creed or belonging to an actual creed. Courts and tribunals have routinely determined that political opinions or beliefs cannot be considered a creed within the meaning of human rights legislation, nor can personal opinions, such as natural immunity, which are distinct from a recognizable, cohesive belief system or structure as it was adopted in Sharma. And some other protected grounds that we just wanted to discuss briefly are family status, political belief, and age. So far as family status and age go, they're sometimes often brought in together as well, because I mean, a common scenario would be like an adult person accompanying a minor who's not vaccinated. And if they're discriminated on that basis from, let's say, accessing a service, then the grounds of family status and age may be brought up. And on the contrary, there may be a scenario where a parent who chooses not to get vaccinated is accompanied by a minor and they want to access a service such as a sporting center where the minor, is a member and they want to participate in activities there. And so in that case, of course, the duty bearers have a duty to accommodate the parent who's not vaccinated to be able to access those services for the sake of their child. And in that case as well, family status may be brought up. Bridget will talk about political belief.
Yeah, and just something to say, I mean, in relation to family status, this would be, in terms of a minor, it would be a minor that's not eligible to receive the vaccine, right? So it wouldn't necessarily be a 16-year-old that is eligible to receive it. So where you have someone under the age of 5 that the vaccine has not been approved of, and a family member is discriminated on the basis of their child not being eligible to receive the vaccine. And so you have, on the one hand, family status for the parent, and on the other hand, age for, let's say, a child that's under the age of 5 and can't receive the vaccine. Political belief is an interesting one. And it's one that gets discussed where people ask the question, what if someone says they can't get vaccinated because they have a political belief, which is that the government shouldn't be mandating vaccines in the first place? The interesting thing about that is we have a recent decision in the area of mandatory masking policies or mandatory masking legislation out of BC. It's called the Complainant and John Horgan, which is a 2021 decision of the BC Human Rights Tribunal. And they make what's a really interesting point. So just because a person has a political belief, and it might be true that someone is opposed to government policy mandating vaccines for political reasons, that does not provide a person with license to not follow the law. So in the John Horgan decision, the tribunal makes an analogy with drug laws. So if you had political belief that was opposed to current and existing drug laws, which is actually becoming more common these days and might even be justifiable, that isn't going to get you out of being charged if the police find 50 pounds of heroin in the trunk of your car. You could not say that, well, wait a second, you can't arrest me. That's discriminatory on the basis of my political beliefs. So similarly, the requirement to follow validly constituted and validly ordered public health measures or public health orders, you can't use political belief to say, well, I can't get vaccinated, or you can't ask me to prove my vaccination status because I have a political belief against the very practice. Where, however, political belief could ground a human rights complaint would be, let's suppose that you're an employer and one of your employees signed a petition calling for the repeal of public health measures, including proof of vaccination mandates. You could not, in the absence of proving a bona fide occupational requirement, terminate such a person or discipline them for participating in that sort of political activity, or where a person's door knocking, or talking about their opposition to things, or associating with others who are doing similarly. So if somebody is plugging someone who's very active in terms of their opposition to vaccines, those things might very well ground a complaint in political belief. But to be clear, political belief is not an exemption from either getting vaccinated or providing proof that one has been vaccinated in compliance with vaccine mandates that have been passed in the territory. And this probably does apply elsewhere. We know at the very least that it applies in British Columbia. Now, this is interesting privacy. We typically do receive a lot of calls about this where someone says, well, providing my proof of vaccination certificates is a violation of my privacy. And to be clear, we tell them, and of course we say it here again, privacy is not a protected characteristic under the Act, though there is an Office of the Information and Privacy Commissioner for Yukon. So we typically tell people that where they have an issue that concerns privacy or alleged breach of privacy, they ought to consult with the Privacy Commissioner's office on that. Employers, landlords, and service providers are all governed by human rights legislation, which prohibits discrimination based on protected characteristics. They're also governed by privacy legislation, which governs the collection, storage, and use of personal information. So, of course, we deal with the former. Privacy Commission deals with the latter. Where they might intersect, probably going to be very rare. But suppose where certain people, you go into a restaurant, and the only people that are being asked to demonstrate their proof of vaccine are people from certain ethnic backgrounds, that would naturally ground a human rights complaint if that were to happen. But from what I can tell, it doesn't seem to be a problem yet anyway, but that would be the intersection of, asking people to provide documentation. So it wouldn't be strictly speaking a violation of privacy, but where only certain groups are being picked on, as it were.
So we'll now discuss the duty to accommodate. We have a definition for this within the Act in Section 8, and it goes, every person has a responsibility to make reasonable provisions in connection with employment, accommodations, and services for special needs of others. But this duty does not exist if making the provisions would result in undue hardship. So the definition itself is quite straightforward, but one point to note is that reasonable provisions basically mean, making provisions that to a point of undue hardship. So it's quite simple, the duty to accommodate. So a few points to note is that if duty bearers are implementing the proof of vaccination policies, again, like we discussed in the beginning, to address specific safety concerns and under public health regulations, then they will still have an obligation to accommodate those who are unable to get vaccinated for reasons relating to their personal, to their protected characteristics or grounds, to the point of undue hardship. And we will discuss undue hardship in a little bit more detail in a little bit. The second point to note is that seeking accommodations is a collaborative, it's a two-way process. So under the law, individuals who are seeking accommodation need to communicate with duty bearers the same way that duty bearers have a duty to try to accommodate those individuals. And this can also include the duty to inquire, for instance, on the part of employers. And this is provided in more detail in Central Okanagan School District number 23 versus Renault. And then the third point to note is that there can be many ways to accommodate an individual, especially with regards to mandatory vaccination policies. You can create requirements to wear face masks or have physical distancing options, or implement periodic tests for COVID-19, etc. So that would depend on the organization that is implementing those policies and the specific accommodation requests by the individual.
So a few things to note there. Undue hardship, and this is in section 8 of our act. Undue hardship shall be determined by balancing the advantages and disadvantages of the provisions by reference to factors such as safety, disruption to the public, effect on contractual obligations, financial costs, business efficiency. This is not an exhaustive list. It's important to bear that in mind. Some of the case law that interprets this, two leading cases on undue hardship are Miorin, 1997 decision of the Supreme Court of Canada, and Grismer, which applies Miorin in the space of goods and services, includes other criteria, such as, for example, the impact on morale. It's very important to qualify that, which an example of how morale may operate in that space, particularly with vaccine mandates, which has been tried recently in other jurisdictions to some success, and primarily in labor arbitrations, is in particular with respect to health authorities, and deviating too far from requiring their employees to be vaccinated as a disruption to morale. So as health authorities are typically the organizations tasked with combating and eradicating COVID-19, and the horrible effects that has on public health and safety, that morale can be factored in. And this is contemplated in both Miorin and Grismer. So there's no list set in stone about what factors can be considered exclusively. Our Act does list these as examples for expository purposes. There are others. The effect that it has on morale is an example of that. And so this is going to depend on the particular industry that one is dealing with and finds themselves in. Of course, what works for one organization may not work for another. It's also important to note here that to the extent that human rights legislation refers to whether or not discrimination is reasonable and justifiable, that is not a separate ground apart from undue hardship. So there's a lot of case law that says that reasonable and justifiable discrimination is a synonym for undue hardship. It's an alternate way of stating the same concept. So there isn't a standalone category of a defense of reasonable and justifiable discrimination. And so subsets of undue hardship are often things like bona fide occupational requirements, where a particular standard or measure is necessary in the performance of one's duties that can't be departed from. Common example might be an oxygen mask for firefighters. It might be the ability for truck drivers to have a certain level of visual acuity. So you might not be able to hire the visually impaired. Ordinarily, that would be discriminatory. It's a bona fide occupational requirement. But there are other subsets of undue hardship. But it's not a standalone or a category apart from reasonable and justifiable. It basically means this.
And another thing to note, I guess, is also that under case law, a duty bearer will have to give proper evidence of them trying to accommodate a person to the point of undue hardship. So you can't just claim that you had there were unbearable financial costs. You may have to show things like quotas that you have received from different organizations in trying to accommodate a person, or let's say if you have to install a ramp to accommodate a person who uses a wheelchair, you'll have to show that installing a ramp, you can't do that because the financial costs, your business can't bear it. So you'll have to provide actual evidence to demonstrate that.
Go ahead. Yeah, no, thanks.
So we now come to the common scenarios that we brought up in the beginning, in the start. So should we just give the answers?
Yeah, I mean, if this were in person, we would probably pick on you to see what your thoughts are. But since we can't see any of you, and just based on the sheer numbers, that might not work, and it might earn your animosity as well. So we'll just we'll analyze these for you, and during the question and answer session, which will start in 6 minutes or less, By all means, please ask as many questions as you'd like. And as part of that, perhaps we can get your thoughts on these scenarios. But Amna and I will analyze these for you in the time that we have remaining.
Yeah, so the first one is, I'm a landlord. Can I post an ad for subletting my apartment specifying that only vaccinated persons should apply? The simple short answer to that is an organization or a landlord, employer, service provider, they're free to implement whatever policies they see fit, especially in line with public safety and health. A landlord can post an ad for subletting their apartment only to vaccinated persons. However, they may open themselves to, discriminating individuals who are not vaccinated if those individuals have personal characteristics and are, prohibited from getting vaccinated based on those personal characteristics. But outside of that, it's okay for landlords to post ads with any sort of specifications.
Scenario number 2, this one's interesting. I have an undiagnosed condition that precludes me from getting vaccinated. I rely on herbal treatments to deal with my medical issues. What do I need to provide to a restaurant? And I think that last part is, supposing that you wanted to go to a restaurant, what would you need to provide in the absence of a vaccine certificate? So the first part of that is to understand what's meant by undiagnosed condition, right? So we can interpret this in one of 2 ways. The first is where people they're seeking medical treatment, but the doctors have no idea what's wrong with them, which isn't to say that they don't have symptoms which are connected to a disability. If the specialists are trying to figure out what particular, for instance, autoimmune condition they have, physical disability, or I should say disability more generally, not necessarily physical disability, but disability would apply despite the fact that there is no diagnosis. And the failure of a diagnosis is, of course, the limitation of modern science in pinning that down in a quick way. But physical disability or perhaps mental disability would apply there. If what is meant by undiagnosed condition is a person has not actually seen a medical professional, they simply have something that's bothering them, and or it's self-diagnosed, so it's undiagnosed in that sense. And just to add throw another spanner into this, if a person says, well, here's a medical note, and I use the word medical note slightly more loosely in this circumstance, but here's a medical note from a naturopath or someone, what's the other word? Not naturopath, homeopath. Thank you. That's it. Presents a note from someone like a homeopath or a naturopath. What impact does that have? We know that naturopaths and homeopaths are not regulated under the Health Professions Act. There's a single reference to naturopaths under ATIP, but that's for the purposes of sharing medical information. So, and it makes a lot of sense that a naturopath, if a person comes to them with a complaint, shouldn't be sharing that, but a naturopath is not in a position of diagnosing, at least under the laws of the territory, of diagnosing anything. And so depending on what's meant by undiagnosed, the answer might change, right? So if it's undiagnosed where the doctors are working on it, there'd still be some protection. If it's undiagnosed in the sense that there's been no treatment or no attempt to diagnose it, or the diagnosis is from someone who cannot legally offer a diagnosis, that would not exempt someone from the vaccine mandate. Fair enough if someone relies on herbal treatments, but that's, again, connecting to who's diagnosing the condition. What do you need to provide to a restaurant? So I should state at this point that the Yukon Medical Association takes the view that there are only 2 things for which they would provide, or their members would provide, a medical note or medical certificate indicating that a vaccine is contraindicated. The first is anaphylaxis as treated by an allergist after the first dose of the vaccine. And the second is myocarditis as diagnosed by a medical doctor. So in both those cases, the Yukon Medical Association has taken the view of the conditions and the person authorized to diagnose it. So those are the only circumstances, at least according to the Yukon Medical Association, that would warrant an exemption from the requirement to be vaccinated or to prove that you're vaccinated. So if you do have such an exemption, there you're going to provide a medical note or a medical certificate that indicates ideally that it is because of a disability. I acknowledge that disability is a legal term, not necessarily a medical one, but that indicates that there's a disability and ideally indicating that the vaccine is contraindicated. And Pelletier does provide some guidance on this, which is a case that both Anna and I have referred to out of Alberta, which talks about some of the specifics that should ideally be produced in these circumstances. So that's probably what you need to provide to the restaurant if you're not providing them with your proof of vaccination together with your ID that I'm sure a lot of us are used to by now. So that's number 2.
The third question is, I don't need to be vaccinated because I believe that God will protect me and my employer is mandating vaccination. What are my rights? So again, Pelletier is actually very helpful in answering this question as well, in that, and as Biju has gone over case law like Amsterdam, which gives us the test for sort of determining what religious belief would mean under the law for the purposes of the law. So a person, if they're claiming that they don't want to be vaccinated because of a religious belief, then they have to establish, whether their belief is sincerely held and meet the test under Amsterdam and other case law. And the employer then has, the right to determine objectively whether their belief is sincerely held or not. And so in that case, if the employer finds that this individual has a religious belief, then they are protected within our act, and they should be accommodated to the point of undue hardship. And so those are their rights under the act. Yeah.
I'll just add one quick thing to that. So the employer will determine whether the measure or should be looking at whether the measure that they've engaged objectively interferes with the religious belief. The existence of the religious belief is not an objective one, it's a subjective one. So the sincerity of the religious belief. So if someone says, in this case, I believe that God will protect me, therefore, the requirement that I prove to my employer that I've received both doses of the vaccine, the question is, does that measure, when objectively viewed, infringe the religious belief? In this case, I believe that God is probably far too nebulous to be a religious belief. By definition, any person of any religious persuasion whatsoever will believe in God in some way, shape, or form. That's way too hazy to be a religious belief. There's going to have to be something more specific than that. Once you're provided with something more specific, so for instance, if the belief is, I believe that I can consume any intoxicants. That is the basis. Well, objectively speaking, does the vaccine intoxicate? It's a shot of Moderna, it's not a shot of tequila, right? So it's not, in all likelihood, going to infringe that religious belief. So the only subjectivity in any of this is whether one sincerely believes in the particular belief or practice. Wonderful.
So we can very briefly go over our complaints process. So once a complaint is brought to the commission, filed with the commission, the first step is for the director to do a preliminary analysis to determine whether or not it may be, accepted, like questions like jurisdiction, time limit, etc., and whether there's a nexus from the complaint form that they've provided between the protected ground that they're a member of and the unfavorable treatment that they've claimed has happened to them. And if the complaint is not accepted, then complainants have a chance to appeal it within 30 days. If it is accepted, then one of two things can happen. It may either go to assigned to a human rights officer and go into its investigation, or the first thing that the commission tries is for the issue to be settled. So we try to go for early resolution. We give that option to the complainant and the respondent. Another thing I should note is that up until the public hearing part, the complaints process is confidential and it is free. Once it becomes a public hearing, it's of course not confidential to the parties only. The commission is a neutral body, so we disclose the complaint to both the complainant and the respondent and give them a chance to participate in the process equally. If the complaint is not settled, then it goes into investigation, where a human rights officer will gather all the relevant evidence, speak to the witnesses, collect all the documents, and then based on that information and case law, determine whether or not there's a reasonable basis in the evidence that a discrimination has occurred and the respondent has failed to accommodate that person. And if it is determined, then based on the findings of the investigation, it goes into a disposition hearing where the commission members may either accept the results of the investigation or they may dismiss the complaint. If they're accepted and the result of the investigation was that there was discrimination, then it goes to public hearing. If they dismiss that result or it is established that there was no discrimination, then again, there's a chance to appeal it within 30 days. And again, settlement is encouraged throughout the process, including when it goes to a disposition hearing. And the process is remedial and not punitive, so the remedies work accordingly. And I think I've covered everything.
Okay, so of course, if at any time, we're always happy to deal with questions that people have in terms of our process or in terms of anything else. So those are our contact details, email, direct line, and our physical address. So I think that's going to conclude the presentation component of this. So let's remove the screen share. And I guess now is a Q&A session. And again, I'm sure that questions about anything that we've covered here or anything else that touches upon vaccine mandates, whether public or private, we would encourage you to ask those questions now, and please don't be shy.
No, it's okay. All right, hello again. So we have a question from Joy Corton, which is, so if a person has a medical condition and is advised by a medical doctor not to get vaccinated, but does not meet the Yukon exemptions, they may be able to claim disability?
Sorry, could you read that question one
more time? A person has a
time?
medical condition and is advised by a medical doctor not to get vaccinated, but that does not meet the Yukon exemptions. Could they claim disability?
That does not meet the Yukon exemptions.
I guess the first question is, would that meet the Yukon exemptions?
Right. Do you want me to answer this? So I'm just wondering, as a point of clarification, if a person has a medical note indicating that they cannot receive the vaccine due to a medical condition or medical disability, there aren't separate Yukon exemptions apart from that, right? So in terms of exemptions, if what's meant by that, as I mentioned, the Yukon Medical Association takes the view that there are only two conditions where the vaccine is contraindicated. If I think the thrust of Joy's question, if it is that if a doctor says it's something other than those two, will it meet, will that amount to disability? That's an interesting question, because I think what would be involved there is for example, if other jurisdictions are dealing with this differently. And my understanding is that the Yukon Medical Association's position is based on positions which are similar, if not identical, across the country. You are going to have medical doctors that may depart from that, right? So that which does happen. I think the position that we take is, if we have medical information, we don't need a diagnosis. So we're not going to know ourselves, is it myocarditis? Is it anaphylaxis? I think I say that more, for the purposes of information, rather than that being strict guidance on what we're going to do at the commission or what a panel of adjudicators is going to do. So if there is evidence that it is a disability, as Amna indicated, disability is to be interpreted broadly. There are very few things which are not going to be considered disability. But there again, the restriction therefore is I cannot get vaccinated. And the medical professional says that, in all likelihood, the complaint is going to be accepted. I think the form in which it's going to be determined whether or not a disability exists, and secondly, whether the disability was such that the requirement of vaccination had to be accommodated through some other means, is going to be through a panel of adjudicators or a human rights tribunal in another jurisdiction. But I just want to make sure that I understood Joy's question correctly, if that interpretation of the question was in fact correct. Oh, wonderful. I understood. Nicest thing anyone's going to say to me this week. You understood. Thank you, Joy.
All right, so we have a question from Leslie McCrae. I'd appreciate a review of creed again. I find that distinction difficult to understand. So let's go back to the slide.
Yeah, sure.
Yeah.
Number 50.
So we get the understanding about creed from case law and cases such as Vazina and Sharma, Sharma being the more recent one. In Vazina, the definition of what creed could mean under the law was, as I mentioned, taken from the Ontario Human Rights Commission's policy on preventing discrimination, and it has since been adopted by other tribunals in understanding what creed could mean. And so creed is a belief that is sincerely, freely, and deeply held and is linked to a person's self-definition, governs one's conduct and practices, and provides a connection to a community with a shared system of belief. And that's how it is, I guess the most common difficulty in understanding creed would be comparing it to religion or personal belief or political belief. And the distinction there is basically the last two parts of the test that we get from that policy, that it addresses ultimate questions of human existence. And then the last part of there has to be some nexus or connection with an organization or community that has the shared system of belief. And that's yeah, okay.
And yeah, I'll just add something to that. Here's I think where the distinction could be drawn, right? So if the question is, well, what's the difference between religious belief and creed? How do those protections operate differently? It's important to understand historically how the law has treated this. So going back to a case called Jazairi out of Ontario in 1996, Jazairi made no distinction between religious belief and creed. So that effectively the test was from Anselm that you had to have a sincerely, you had to have a sincere belief with a nexus to religion. As we've moved on as a society, and where Vesna inserts a very important departure from that, is the fact that there are things such as indigenous spiritualities, which don't conform with historical understandings of quote unquote religion. Right? So it's not Christianity, it's not Judaism, it's not Islam, it's not Hinduism. And therefore, what Vesna is attempting to do is to say, well, here are a criteria of 5 things. And if you take a look at the slide, it's at paragraph 10, the 5 features that Amna mentioned. So if you meet those 5 criteria, chances are that's what's going to be required to establish that there is a creed. Right. So the 5th feature is a connection to an organization or community that prefers a shared system of belief. So it's going to be very difficult for a single person tomorrow to fabricate something that says, well, I believe that I have the creed that vaccines are terrible, that, it's government overreach, that natural immunity is enough. If nobody else believes that and there's no community, tribunal's hardly going to find that exists. And so conceptually, that's where creed departs from religious belief in terms of how the protection operates. Noting that it's very important to understand that even if there's a protected characteristic, the usual defenses still apply. So a person could establish creed, and yet a respondent might say, look, undue hardship doesn't really matter. But if we've understood the question in terms of the distinction, right, between creed and religious belief requires a nexus to religion, right, such that the failure to provide that nexus will mean that you failed the test. Creed doesn't require a nexus to religion, right? Instead, there are a list of 5 criteria. They're not exhaustive. They're meant to be a guidance to determine whether the thing asserted is creed as opposed to something else. And this is important because Vesna also says that whatever creed you profess, it can't be political belief. There has to be a distinction between protected characteristics. So if what you're really attempting to argue is a political belief, it's not going to fit creed. That's important in jurisdictions that don't have political belief as a protected characteristic. In the Yukon, we do, and in fact, in the Yukon, it's political belief is probably among the most robust articulations of the protection of anything associated with political activity of any place in Canada. In a lot of places, it's limited to partisan participation, for instance. So hopefully, at least that answers. And I've answered that part of the question insofar as we understood it.
Leslie says, thank you, that was helpful.
Wonderful.
Next up is a question from Bob Dean, which reads, does the Human Rights Commission defer to the Yukon Medical Association in deciding the specific grounds for an exemption? I'm thinking of I'll read it as it's written. I'm thinking of a pregnant man or woman who is concerned about stillbirths based on known data.
Based on known data. Okay.
Sorry, can you read the entire question again? With the
Does the Human Rights Commission defer to the Yukon Medical Association in deciding the specific grounds for an exemption? I'm thinking of a pregnant man or woman who is concerned about stillbirths based on known data. So as I take it, does the Human Rights Commission come up with its own grounds for medical exemption, or would it defer to medical professionals? Is that how I read it?
Right. Do you want to answer that? Okay. So I think, generally speaking, deferring to the YMA, I mean, is interesting, right? So naturally, what's important to understand here is when disability, as I mentioned, is not a medical term, it's a legal term. And again, broadly speaking, very few things are not going to be captured by disability. I think it's not so much that we defer to the Yukon Medical Association, and we look at everything on a case-by-case basis. I think the Yukon Medical Association's position is helpful to understand what their practitioners are doing, right? So they are telling their own membership that you should only issue exemptions for these conditions. So it's kind of an indication that people are probably not going to get medical notes from a member of the Yukon Medical Association unless it follows one of those 2 things. Now, that being said, if we did receive a complaint, let's say from a person whose medical doctor, as a lot of us know, 20% of people who are residents of the Yukon don't have access to a family doctor in the territory. So they might be getting medical care from family doctors outside the territory, whose understandings of these things are slightly different. So we're not going to defer to the Yukon Medical Association. Hopefully that answers the question. The only reason to bring up the Yukon Medical Association is just so that people understand that it's going to be very difficult to procure medical notes, at least as far as the YMA is concerned, outside of those 2 scenarios. We base things on, especially at the complaint acceptance stage, we don't require evidence to determine whether or not a human rights complaint should be accepted. We assume facts most favorable to the complainant, and we assume everything that they allege is true. So unless, of course, it's physically impossible, or unless what's being alleged is on its face, and this is from the case law, unless it's patently unreasonable to assume it. So if a person says, I'm a pregnant man or a pregnant woman who is concerned about stillbirths based on known data, again, the question we're asking ourselves is, are you going to be able at some stage of the process to prove that. So again, on facts as alleged by the complainant, that may give rise to a human rights complaint. It may not. But the standard of proof there, and not just on religious belief, it should be said, but really on any protected characteristic, it's just more challenging with religious belief. You have to always show that what you are alleging is objectively speaking an infringement of the act, if it were to be proven true. I think we live in a time where this is becoming difficult because what known data is being disputed by people, right? So someone will say, there is known data on this, right? And especially in the context of the pandemic, where people get their information is becoming a site of contention. So the onus is on the complainant in the first place to prove their case. So again, if it is actually known data, fair enough. At the complaint acceptance stage, we're not dealing with evidence anyway, right? So we're dealing with what a complainant asserts. If what they're asserting would be true, such that it would give rise to a human rights complaint, if it were true, then the complaint will be accepted. As you move through the process, there's going to be a requirement for evidence, and that evidence will be assessed, it will be weighed like it would be in any other legal proceeding. At that stage, it's for the trier of fact to determine whether or not, the validity of that data. Hopefully that answers the question.
So Luke Fott asks a question: how does 10D of the Yukon Human Rights Act play into this? And then he quotes from the statute: it is not discrimination if treatment is based on other factors establishing reasonable cause for the discrimination. Is preventing disease transmission reasonable cause?
Sorry, I'm just looking for it here.
Sure, it's in the chat window.
Oh, it's in the chat window. Okay.
And so, forgive me, Luke, if I mischaracterize this, but I think what he's getting at is if a complainant was able to establish discrimination on a protected ground from a COVID vaccine mandate, could the respondent nonetheless claim that the public health objective is so pressing that it overrides the discrimination?
Do you want me to answer that?
I'm sorry, I'm confused. Is this the question from Luke?
Yeah, looks like, yeah.
So how does section 10B of the YHRC relate to this?
Yeah, so it's not discrimination if treatment is based on.
I'll let you take the questions.
Okay, sure. So, so number one, I will say that, and as Amna mentioned, subject to the fact that anytime one is saying reasonable cause, right? So it is not discrimination if treatment is based on factors establishing a reasonable cause for discrimination. So terms like reasonable cause, reasonable justification, as I mentioned earlier, is not a standalone category outside of accommodating to the point of undue hardship. So in a sense, to reframe this, Luke, if a respondent were to say, hey, look, we can't because we have to prevent disease transmission. So is disease transmission reasonable cause, or to put in other terms, would that amount to undue hardship, right? So it could be, of course, you could advance the argument that, preventing communicable diseases from transmitting would certainly be a valid argument. What you'd have to do is you'd have to demonstrate that there was no way to accommodate that person, right? So, and this is going to depend on a number of facts, right? So, for instance, if you're working in a hospital and you don't have the capacity or bandwidth, it's just based on the variables in a hospital, we can accommodate a surgeon in an operating theater from not being vaccinated. That's an environment where everything has to be sterilized. There's a heightened requirement in favor of infection prevention and control. Subject to providing evidence of it, absolutely. As Amna said, there are very few magic words that simply, invoking the terms are going to vindicate your position. So you'd have to prove it. as a goal, and if you look at, again, Murin and Grismer, but let's stay with Murin, which is a leading case, there's a three-part test, and it is a mouthful, so I'm going to paraphrase it. First, have you adopted the standard? This is part A of Murin, and forgive me if I don't quote it exactly. I have no choice but to go on memory. But the first part is the measure adopted connected to, is it connected, is it rationally connected to a function, a legitimate function? Second, is that measure adopted in good faith and under the belief that it is necessary? And finally, would accommodating someone with the characteristics of the complainant lead to undue hardship? So the test is firstly a rational connection test. The second, adopting a standard which is adopted in good faith and under the belief that it is necessary. And lastly, could you not accommodate someone with the characteristics of a putative complainant without incurring undue hardship? So if you look at those three things, is the prevention of disease transmission, is adopting a vaccine mandate, generally speaking, rationally connected to the function, the very legitimate function of preventing disease? It probably is. Second, is it adopted in good faith and in the belief that it is necessary? So again, that speaks for itself. Is it in good faith with the belief that it's necessary? If you adopt it in good faith and believe it's necessary, you'll probably overcome two. Lastly, we come to undue hardship, right? That's where you're going to, the first two isn't going to require a lot of proof, the last one will. As long as you can explain that here's why we can't do other things, short of having someone being employed while unvaccinated, like we can't have them work from home, we can't have them wear protected, personal protective equipment, then you'll be all right. But you're going to have to argue the case. Sorry about that. If that was long-winded, Luke, I just wanted to make sure that we captured all reasonable interpretations of your question. But, you know, give us a thumbs up in the chat or a smiley face or a yes or something so we know we covered most of it or all of it.
Right, thanks. Actually,
okay, smiley face. Thank you.
Okay.
Do you think that'd work?
Actually, I just noticed that I skipped a question from the chat window, so I'm going to back up to 12:55 p.m. So the question is from Tashi Alfred. To what extent, if any, does the evolving nature of the COVID pandemic bear on your discussion here? E.g., what if COVID were to spread more quickly or cause less severe infections, etc.?
I should let you answer that.
To what extent, if any, does the evolving nature of the COVID pandemic bear on your discussion here? I think since we are addressing vaccine mandates that have been implemented by the Yukon government and other organizations independently of that, the basic test for discrimination and duty to accommodate to the point of undue hardship remains the same under the Act. What changes is, the thresholds for certain things, like let's say for using the ground of age, if the vaccine mandate changes for children under 5, then that would change according to that. And so initially we were dealing with a lot of inquiries related to masks mandates, and then it switched or moved over into vaccine mandates. The basic issues remain the same, and the tests under the law remain the same, although there's new case law coming out, increasingly with regards to COVID specifically. But I don't think that outside of that, things would change.
And again, unfortunately, the legal system is not equipped to move in hours or days. You're lucky if it moves in weeks. So, I mean, part of this is the jurisprudence on this is trying to catch up to a very quickly evolving pandemic as we've seen. I mean, Omicron, I think, was announced just a couple of weeks ago. And already it's, there's a lot of concern both internationally and nationally. We've already had, I think at the end of last week, 2 cases announced in the territory. So I think, yeah, we are constantly trying to roll with this as best as we can. And in the absence of case law, this is far from an inexact science. I think what we're trying to do in making decisions on this, as is every other human rights commission in the country, is we're trying to reason as best we can by analogy. I don't know that we get it exactly right 100% of the time, but we certainly are doing everything we can. I think a lot of us are becoming, almost hobby epidemiologists, where I know my day starts off as reading all of the news stories, reading medical journals, corresponding and communicating with my counterparts across the country, some of which I used to do, before all of this happened, but some of it is kind of new, and with a hope of understanding where everything is headed. But yeah, so the answer is, to a great extent, the evolving nature of this bears on our discussion here, right? So if Omicron changes things, it could be that to be fully vaccinated is not 2 shots. That actually might be upon us sooner rather than later. So those definitions are going to change. And naturally, the arguments from people against vaccinations may change in turn as well, where they might say, look, we were okay when this was 2, but you're making us now take a chemical routinely, repeated ingestion. We're not okay with that. So again, the tensions are going to be trickier, I suspect. We're certainly going to be considering all of that as this moves on.
Thank you. All right, we have one more question submitted, and if anyone's been sitting on one, now's the time to type it in, because we're coming to a close here. So the question is from an anonymous attendee, and it's sort of the flip side of the typical complaint that we've been discussing all along. And so the question reads, could an employer's refusal to adopt, enforce vaccine or mask mandates ground a complaint by an immunocompromised person claiming that the lack of mandates has the effect of discrimination against that person?
I'm just going to say, by the way, that's a brilliant question. Not that the other questions weren't, in their own way brilliant, but, that is really an excellent question. Look, I think there are a couple of, Leo, there are a couple more questions also in the chat.
Oh, okay.
I think, yeah. So, do you want to answer that?
Go ahead.
Okay. No, I think that's a fabulous question. I say that because where this was actually attempted was in Alberta back in September. Exactly this. So while they were, and this is in the context of charter challenges, of people saying that the mandates, and at the time, Alberta had recently, and after a lot of public attention, adopted announced proof of vaccine requirements, or what they called restriction exemption programs. So there were groups that begin bringing actions against the government for not having acted sooner. And a lot of the people were groups represented people who were immunocompromised, for instance. I think from a human rights law standpoint, I think one of the things that we would consider certainly is where if a person filed a complaint that said, I am immunocompromised, I work in an industry or a workplace where my employer has not is not requiring people to be vaccinated, and now I can't come to work. Again, we would follow the Moore test, right, in analyzing that. So, A, does the complainant have a characteristic protected under human rights legislation? Yeah, being immunocompromised would be a disability under the Act. Second, have they suffered an adverse impact? That's where someone who's immunocompromised, in attempting to bring such a complaint, as categorized by the anonymous attendee, would have to show that they have suffered an adverse impact, or as the Yukon Act calls it, unfavorable treatment. In the absence of unfavorable treatment, it won't proceed any further. But if there is adverse treatment, so if a person says, well, depending on what the work is. So for example, if a person says, look, I've been placed on some sort of administrative leave without pay, or, I'm being excluded. Like sometimes, the unfavorable treatment can be a little bit more subtle. I'm the only person excluded from the office, and now no one ever talks to me. My boss doesn't talk to me. I'm being excluded from the office space because I'm immunocompromised. That might be something we consider. And finally, is the protected characteristic a factor in the unfavorable treatment? It doesn't have to be the overriding factor. It doesn't have to be the only factor, does not have to be the primary factor. It merely has to be a factor. If that is the case, then a person may be able to make out a complaint that says that the failure to actually have a vaccine mandate or a mask mandate is in fact discriminatory. Once that happens, the onus is going to shift to respondent to show why they could not accommodate that person's request to the point of undue hardship. But here again, it's important to understand also, and I should add this because this is a really important qualifier. You are not accommodating personal preference, you're accommodating a condition. So if someone's immunocompromised and they present a medical evidence that identifies one of the restrictions or one of the accommodations as being this person must work in an environment where everybody is vaccinated and has proven that, that's about the only circumstance I think where that could be considered. Because a person might have individual preferences, and the law says Central Okanagan School District and Renault is probably the leading case on this. Back in 1992, still stands the test of time. The accommodation must be reasonable. It need not be perfect, and it need not be the complainant's preferred form of accommodation. So all of those ingredients have to be in the mix for a person to actually sustain a human rights complaint. So I suppose rather than answering that in the most directly possible, those are some of the ingredients. So I'm not trying to flip this back on the questioner, but that's basically the ingredients that would be required. So if all of those things are there, then the answer is yes. If one of those is missing, then the answer is in all likelihood no.
I do want to highlight like one of the points that Beju mentioned. So in the second part of the test that where you have to determine adverse treatment or unfavorable treatment, it will be important to show that the adverse impact or treatment has already happened. So it can't be in anticipation of something happening. And I think that's where I think that will be a very critical component in this respect of this immunocompromised person actually bringing a successful complaint to the commission on the basis that their employer is refusing to implement a policy. They will have to show that they have, already faced adverse treatment and not in anticipation of it for the lack of the policy being implemented.
Yeah, and that's a really important point that Amna just raised. And it's one of the reasons why one of the things that we would tell people that would call our offices before November 30th is we would tell them you can't file an anticipatory human rights complaint. So if the harm hasn't materialized or the unfavorable treatment, to use the language of our act, then you can't bring a complaint in anticipation of that. Like those ingredients have to exist, in this time and space continuum, as opposed to a different one for you science fiction fans out there.
All right, thank you. I think that's the end of the questions, unless somebody submitted one to you in the private chat.
You mind if I just hold on? I'm just
go ahead.
reaching across here and just above.
I think we went through.
Yeah, like there's a okay. There's two. I think. I mean, they're mostly follow-ups. So there's two follow-ups.
Sure.
One of them might still be live. One of them might not be. And so Leslie asks, but not every medical condition can be considered a disability. Correct. So again, for the commission to have jurisdiction, there has to be a disability, right? So an example of a medical condition which can't be considered a disability would be a cold.
Or
right?
stress.
Yeah, and we also have to, symptoms aren't disabilities, headache in the absence of more, right? So this is correct, right? That not every medical condition can be considered a disability. It should be noted that, and again, while there is a broad liberal and purposive interpretation afforded to human rights legislation, and this includes disability, number of cases on that, not every condition will, right? So if there's no disability, there's no jurisdiction. Hopefully that answers Leslie's follow-up. And Joy asks, and I think, again, this is probably, I think this is a Creed thing, which is, so where is the line? This comes after having under, I'm trying to go back to Joy's original question.
I think it's a back and forth between Joy and Leslie about that original.
Oh, I
question
see.
about the medical condition.
Not a question for me. Okay.
There's a couple. Okay, yeah, there you go. Joy says mine is about a disability. So, yeah, it looks like she was just continuing on what you already talked about.
Yeah.
All right. Okay, we got one in just under the wire. This will be the last question. It is 1:25, and it's from Brooke.
Oh, yes.
Nielsen. How can businesses best assess religious exemption requests from religions that they are not at all familiar with and can only find minimal info online?
Yeah, this is a fantastic question. No, I think this is an excellent question, right? Because here again, and this is where the pandemic has really changed things, right? So in some ways, responsibilities have been downloaded onto duty bearers to basically navigate and acquaint themselves with information that they ordinarily wouldn't as part of their day jobs, right? So as I mentioned, that we've sort of become hobby epidemiologists. We've also become leisurely theologians and philosophers and things of that nature. And I appreciate the difficulty that comes with that. And one of the ways to understand this, and thank you for that question, Brooke, is there are two possible approaches. And this really depends, right, on the context. And so I'm going to speak generally, and then we're going to try and, maybe apply this to the specifics of the mandate. And so when someone says that they have a religious, belief that requires accommodation, there are certain sorts of questions that you would be expected to ask, generally speaking. So if someone said, hey, look, I have to pray at certain specific times of the day and I need accommodation, you're not asking questions to sort of be intrusive, right? And to quote the BAR's decision or the Bears decision out of Ontario that I mentioned before, inquiries into sincerity should be limited, right? So what you're asking is, if the question was, hey, I need to pray at specified periods during the day, it might be, well, okay, how much time do you need, right? Is it a congregational prayer? Is that alone, or do you need people? Is it audible or is it silent? At what times during the day is it? So you're asking questions to determine whether you can accommodate or whether accommodation is necessary in the first place. That being said, it's increasingly difficult in a pandemic context, because I think with vaccine mandates, what's being asked is, I can't get the vaccine because I'm part of religion X. And so you can ask, well, what is the belief? And depending on what the belief is, the question then becomes, does the measure infringe on that belief, right? So there again, it's intoxicating, right? Or the tricky one of the trickier ones is it's stem cells. I think there, what's important to understand, as the Supreme Court of Canada has said in Scolaire Deschênes, is that it's not enough to say that this might interfere with my religious belief, or it's not enough to say that I believe that this will interfere with my religious belief. The onus on a complainant, to be clear, is that the measure or the thing adopted by an employer or service provider, the duty bearer, does in fact, when objectively viewed, actually infringe. So a complainant is going to have to demonstrate this actually infringes it when objectively viewed, which in some cases is difficult. So if someone's saying, hey, I can't take the vaccine because of stem cells, the burden of proof is on them to show that what is being injected is actually stem cells or some stem cell derivative. The burden of proof is on the complainant, not on the respondent, because the respondent is not in a position where they have to prove they did not discriminate ab initio, right? It's only where a complainant has established their case that a respondent then shows, hey, I couldn't accommodate this person to the point of undue hardship. Now, in practical terms, how do you assess it? Two things, right? The first is to assess your own capacity. So if you can't accommodate in the first place, let's say that you work in a place where everybody's in very close quarters, right? So City of Whitehorse bus, right? People are sitting very close. It's a busy schedule. You can't have people separating themselves. If you know that a passenger boarding that bus where you're going to require, if such a requirement existed, I'm speaking hypothetically, you might be of the view that it doesn't matter what your religious belief is, we can't have people packed in sardine can-like environments without showing they're vaccinated. And with all due deference and sympathy to whatever protected characteristic is at play, if you know you can accommodate them because those are your circumstances, don't get into the theological discussions, right? I mean, it's unproductive and it's pointless anyway, because it turns out you're not going to be able to accommodate them, even if all of that is legitimate and in good faith. And there'll be a number of factors you have to weigh as well. Like, I think ultimately the practical answer to some of this is, in some cases, unless it is very clear that it's shady, and you know, businesses to a certain degree are going to have to assess this, but in very, very clear cases where it's plain and obvious, don't ask too many questions about it. Jump right to the question, can I accommodate this person? If you can, great. If you can't, so be it. And again, a number of things might weigh into that, including for businesses, the penalties associated with non-compliance as part of the risk analysis. So if you can take a chance, fair enough, right? I think, and Brooke, I hope I've answered that question to the best of my ability. So if you can't find a ton of information, the thing might be, I'm going to assume, again, unless it's just very clear, this isn't, I saw this person on Facebook who was asking other people questions to come up with a religion, you know, like if it's that, unless it's, you know, approximating that level of clarity, you might just have to assume that it's in good faith and either determine, can I accommodate this person or not? Like, you're going to shift the discussion there. And there are a number of factors, some of which we pointed out in our presentation, but again, non-exhaustive lists. If you're facing administrative penalties, if it's morale, you know, all of those things, if you can accommodate it, so long as you can prove that, you know, it's an undue hardship, you'll be okay. But be mindful of what is required of the complainant, that at all times, it is in the first place, the complainant to show those three characteristics and more. When we're talking religious exemptions, the complainant must show that the standard actually and objectively infringes, not that it might, and not that they believe that it might. So if they can't prove it, you'll probably won't be in a position to show undue hardship, because undue hardship is a defense. And you're only required to demonstrate a defense after the complainant has proven A, B, and C of the Moore test. Brooke, I hope that answers that question. Again, like I told Luke, smiley face or why or something will suffice. And I know I should say that we're not going to answer perfectly everybody's questions. Oh, wonderful. Thank you, Brooke. Please feel free to contact us. And I know that some of you already have or may have, but please continue to avail yourself of the services that we offer. And again, a lot of this is uncharted. It's, you know, dark waters. So we appreciate that, particularly both for complainants and respondents, that there are going to be repeat callers. There are going to be repeat callers. And we expect that, we encourage it. Give us a call. But thank you. You know, those are some great questions, a lot more questions, I think, than we've gotten before. And I apologize if Amna and or myself did not answer all of these questions to everybody's satisfaction, but give us a call, send us an email, right? That's what we're here for. And hopefully we can carry on these conversations with you some more. But unless there are any others, and hopefully I'm not trespassing.
No, that's fine. I think we're just barely over time, so I think we'll cut it there. I want to thank you, Birju and Amna, for taking the time to guide us through this emerging area of law. And to the audience, if you want to learn more, I do recommend you visit the Human Rights Commission's website, yukonhumanrights.ca. There's an excellent section there on COVID-19 frequently asked questions that goes not just it goes beyond vaccines to covers mask mandates, things like whether employers can demand to see employees' medical records, other topics. So do take a look at the website. And I would like to thank you to everyone who contributed to the Q&A and to everyone who participated for joining us today, and hope that you all have a safe and happy holidays. Thanks very much.
Thank you.
Thank you.